Good morning, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru Tumarkin, LLP. I'm located in Toronto. As you know, we have offices across the country. We have an office in Toronto, an office in Ottawa, and an office in Vancouver and in Calgary. I've been with you many times doing these live stream sessions. And as I always say, the goal is to answer as many employment law questions as I can within the time that I'm with you, within this half an hour. So please don't be shy, ask your questions, and I will get to as many of them as possible. We want to really educate the public and make sure you understand what your legal rights are. Before we do get into your questions, as I normally do, I'm going to begin with some important topics and information within the world of employment law. So some new information is that we've heard that the CBC has announced that they're eliminating 600 jobs and they have 200 vacancies that they're not filling. They have said that they're not going to do this all at once. It's going to occur over the next year. And many of the layoffs aren't going to happen until April of 2024. Now, why is CBC doing this? So as many companies have said, because there are many major layoffs that are happening recently. And so it's the increasing costs, declining economy, competition from other large companies like Amazon and Disney and Netflix that are creating issues for CBC, and CBC has therefore said that they have to eliminate jobs. And as I mentioned, so many layoffs are happening, especially within the tech and software industries. We've seen layoffs from RBC, Amazon, Spotify, PwC, TD. So we got some of the banks in there as well. And it's really just these companies having to navigate the challenging economic times that we're in. And so where does that leave employees and what severance rights do employees have? And so it's very important to understand that just because a company is suffering financially, that does not change your severance entitlements. The company, if they're solvent, they still have money in the bank, they owe you your severance if they terminate you, and they owe you the same amount. There's no reduction in severance because the company is going through troubling times financially. That's very important to understand. And so depending on your situation, you could be owed as much as 24 months of severance. And when I say depending on your situation, it means that severance is a subjective analysis based on you, based on your age, based on your length of service for that company, based on the position you held, how much money you earned, and generally how easily you should be able to find a new job within your industry, a new comparable job within your industry. And that could be as much as 24 months of pay. Now, it's a good time to speak about our severance pay calculator. So we have a tool, it's free and anonymous, and it's called the Severance Pay Calculator. It's part of our larger Pocket Employment Lawyer tool. And you can find out how much severance you're owed. Like I said, free and anonymous. All it will do is it will ask you some basic questions about your circumstances, your age, your length of service, your position, etc. And then the calculator will calculate the severance that you would be entitled to. You can use it if you've been terminated. You could use it if you've been laid off. You can use it if you have a great job and you don't expect to be terminated or laid off, but you're just curious to know how much severance you might be entitled to. So check out that severance pay calculator, part of our Pocket Employment Lawyer tool. Now, also important things to note is that because severance is determined based on these factors, there's no one size fits all severance package. Many companies, including Spotify, who's also engaging in layoffs right now, say that they're going to give employees who were terminated X amount of severance. And in the case of Spotify, they've said 5 months. So you're going to get 5 months worth of severance. But you could be there for 20 years or more. Um, 5 months certainly would not be a sufficient amount of severance for someone with longer service, certainly someone who might be a bit older who's terminated, because it's going to be harder for that person, generally speaking, to find a new job. And so you can't just give everyone 5 months. There's certainly legal issues with that. So if you're in this situation, of course, please contact us and we will help you out. You can contact us at help@employmentlawyer.ca. Another thing to note, if you're offered a severance package, it usually comes by form of a letter called a termination letter, and that letter will dictate how much severance the company is offering you. And the letter will finish with some sort of deadline, typically. I read termination letters every day. Almost all of them have a deadline that say that you have to sign this package by this date. It's usually a week, sometimes less, sometimes more, or else you're going to lose the offer. You're going to lose the severance offer. So very critically important. Do not sign the package. If you sign it, there's not much we can do for you at all. It becomes a binding deal in most cases. So you can't sign it. You have to call us. You have to make sure that we look at your package and advise you as to whether you are receiving a fair, reasonable amount of severance for you. I think lastly, before we dive into questions, it's important to note we're in holiday season and there are people being terminated, unfortunately, around the holidays. It's a bad time to be terminated and employers should not be doing it. It's not illegal, but it's just not a nice thing to do. But if you have been terminated around the holidays, then arguably you'd be entitled to more severance than if you were terminated in June, for example. And the reason for that is because severance is all about giving you money to get you from job A to job B. And so if you have been terminated around December time, or even beginning of January, it's going to be difficult for you to find job B as quickly as you normally would, because it's just that time of year where people aren't hiring, many people are away, etc. And so you would arguably be entitled to more severance because you need more money to get you by until you re-employ, which would probably only happen sometime in the new year, maybe a month or two in. So all very important things to note. And we'll now jump into questions. I see I have many here. So let's start answering your employment law questions. So we have one from Stephen on Facebook. And Stephen says, my wife was on mat leave and set to return to her position. Her boss had hired someone on contract to replace her temporarily. Now she's hearing from a coworker that there's plans to let her go. Can they do this? No. When you are on a leave, a mat leave, parental leave, sick leave, whatever leave you might be on, your employer has to hold your position for you. Your employer has to hold the exact position, and if it's impossible, then they have to give you a comparable position to the position that you held when you return. Sometimes your employer will terminate you while you're on a leave or shortly after the leave. If the termination had something to do with the leave, something to do with the fact that you were on a parental leave or a sick leave or something of that nature, then you might also be entitled to human rights damages. If you can show that the employer was discriminating against you or failed to accommodate you in some way, then that's a human rights issue as well. And on top of that, of course, you'd be entitled to your normal severance pay. Okay, so I hope that answers your question. And Stephen, if you have any follow-up, please post it into the chat. Sammy on YouTube says, is there a difference between a termination and a permanent layoff? No. A layoff is different from a termination, technically. A layoff could be temporary, where the employer is only laying you off for a certain amount of time. The law says that they could typically lay you off for 13 or 35 weeks, although there's certainly ways to challenge a layoff immediately, even if it's temporary. But a layoff is different from a termination, and a permanent layoff is another way of saying that you've been terminated. You're not coming back to work. Okay. George on Facebook asks, after I completed my probation period, I overheard a manager mention that they were not pleased with my work and would demote me as a means to say they weren't happy with my performance. Can I be demoted in both title and pay? Absolutely not. If you are demoted, then that is what we call a constructive dismissal. Very important topic. So let's talk about it for a little bit. A constructive dismissal is where your employer is doing something that changes the terms of your employment significantly. So, classic examples of a constructive dismissal is reducing your pay, reducing your hours, changing your job location, all sorts of changes that are significant to the regular terms of your employment. You can argue you have been constructively dismissed. So it's not that your employer is sending you a termination letter and telling you you're being dismissed. Instead, they're saying, like they did to George, we're not happy with you, so we're reducing your pay, and you're not going to be a manager anymore. You're going to be an assistant manager, for example. So that would be a demotion in terms of title and pay. Definitely, you can argue that as a constructive dismissal, and you can seek your full severance pay in that situation. The same severance pay that you would be entitled to if your employer actually handed you a termination letter and said you're being terminated. So very important. We see constructive dismissal cases all the time. I deal with them probably every day. And other examples could be a toxic work environment, harassment, and like I said, reducing pay, reducing hours, changing job location, making your commute longer significantly. All of these things would fall into the realm of a constructive dismissal. So George, no, they cannot do that. And please contact us and we will help you. We have a question from Nick on YouTube. If the expected date of recall in the record of employment has not returning box checked off instead of unknown box, is the employee being laid off or fired? No details from the employer. Well, I would expect that would mean that you're being terminated. Every case might be a bit different, and your employer might say they made some sort of error or mistake on the record of employment, which does happen sometimes. But if you're not provided with any other information, you're not being told verbally or in writing that you are actually being terminated, I think you can construe the fact that they check the box saying you're never returning, that you are not returning in their mind, in the employer's mind, and you're being terminated. So Nick, definitely contact us in that situation. And we will represent you, and we will seek your full severance pay. Okay. Next question from Alhi on YouTube. What happens with people who come to Canada with a visitor visa, no work permits? Then some people give them a job and after never pay them. This is a very circumstantial kind of question. So it would be helpful if you call us or contact us at help@employmentlawyer.ca, and we will arrange a consultation with you, and we will ensure to answer your question and all of your questions on this topic. Okay. Let's move on. We have a question on YouTube from Arthur. If your company is closing down the location you work at but offer you a similar position at another location, does refusing this mean you're not entitled to severance? New location is 2 hours away. Good question. Very good. We see this all the time. So if your company is closing down, you're deemed to be terminated. Now, the company might offer you a different position, and an employee who's terminated is obligated to look for work or to accept work that is similar. So similar in terms of pay, duties, job location, etc. And if you don't accept a good opportunity, a promising opportunity that's giving you essentially the same pay, same duties, etc., same commute, then perhaps your severance would be reduced as a result. Now, if the different job that's being offered to you is substantially different in some way, and in Arthur, you said in your case the new location is 2 hours away, and let's say, I don't know this, but let's just say you commuted for half an hour to your current job, and now you're being told that you have to commute an extra hour and a half, a full 2 hours away from your home. So you don't have to accept that kind of position because it's not comparable. It's not comparable in terms of commuting time. So even if the pay might be the same, the duties might be the same, you shouldn't have to travel an extra hour and a half to get to work every day. That's a significant change. So no, you would not have to accept that. You're deemed to be terminated from the employer that's closing down, and you're entitled to your severance as a result. Now, if there is another job that arises, a similar position at a different subsidiary of the company, for example, and the commuting time is maybe 10 minutes longer, but otherwise everything else is the same, well then, yes, you probably should take that job. And if you don't, no one's forcing you to take any job. You can do really whatever you want, but it would have an impact most likely on your severance pay. So as you can tell, every case is different. So it's important to contact us. Let us learn all the details about your situation, and we can advise you thoroughly on what your issue might be. Again, as you see on the screen, there's a wealth of information on our website about all of these topics as well. So look at employmentlawyer.ca, go to that website, and you'll find tons of information on all of the issues. Okay, moving on. We have a question from Brian on Facebook. Brian asks, can you be forced to work overtime hours? We're running on short staff as a result of layoffs, and everyone is worried about saying no, as we could also lose our jobs. So look, I mean, if the company is, if you typically work, let's say 40 hours a week, and the company is asking you to work several more hours, maybe 43, 44 on average, then that's a reasonable request in most cases. It could be that you have a particular conflict, you're not able to do it, Brian, in which case you should raise that with the employer, and they should be accommodating you. If you are working more than 44 hours a week, then typically you will be entitled to overtime pay. So you should be compensated for working those extra hours. Every case is different, and yes, this is probably something that a lot of companies are dealing with because of the layoffs that are occurring all over the place, which I talked about at the beginning of this session. So Brian, I hope that answers the question, and if you have a follow-up, please post it in the chat. So Arthur has a follow-up. Arthur had asked about the company closing down and being offered a similar position at another location, but the new location is 2 hours away. So now Arthur says he's worked at the plant for 14 years, not sure what to do with the change, and a 4-hour daily commute is not manageable for him. That's totally understandable, Arthur. Contact us and we will help you with this. I'll want to see the documentation. I imagine there may not be, but in many cases there is documentation from the company saying this is what the change is. You're being terminated as of this date, but we're offering you a different position as of this date at this location. And let's go through all the details together. We'll arrange a consultation, and we'll see what rights you have. But and most likely, as I said earlier, you're going to be entitled to your severance pay if the company's not giving you any other option except for taking a job that requires a 4-hour daily commute. Arthur has another question, an unrelated question, but a good one, about bonuses. So he says that we receive annual performance bonuses as part of our salary. Is that something that should be included in my pay? So if you're referring to your severance pay, yes, that should be included in your severance pay. If you receive a bonus, it's part of your compensation. So your severance pay should include that bonus. Sometimes there are terms in a employment agreement you might have signed that talk about what happens to your bonus upon termination. So I need to see your employment agreement because it's very relevant in this case. But yes, generally the bonus should be included as part of your severance pay. If you receive it every year, especially if something you rely on, then it's part of your compensation. And on a similar note, what everyone should understand is that not just bonus, not just salary, you should be getting, if you're on benefits, you should be receiving your benefits throughout the period of severance that you're entitled to. If you receive RRSP contributions from the company, you should be receiving that as well. Commissions, any other wage you should be receiving as part of your severance during the period you're claiming severance. So for example, let's say you're entitled to 12 months, 1 year of severance. Well, that 1 year of severance should not just be your base pay, should not just be your base salary or your base hourly wage. It should include commissions, it should include bonuses, benefits, RSP contributions, anything you might obtain. Could be a car allowance, a phone allowance, a gas allowance. All of these things form part of your compensation. Okay. So we have now another question from Alhi on YouTube. Where can I report a company that abuses workers' rights? Well, if this is impacting you particularly, which I imagine it is, then you might have a claim for constructive dismissal. So if you're being harassed or subject to some sort of abuse or toxic work environment, contact us. We'll arrange a consultation with you because you do have rights in that case. You can treat your employment just like you can treat your employment as having ended as a result of a significant reduction in pay or in hours or job location. You can do the same thing if you are being subject to a toxic or abusive work environment. Okay, so Ali, make sure that you contact us and we'll arrange a consultation with you. Another important topic that I want to raise, and then we'll dive into more questions, is what's happening in Ontario with new legislation that Ontario is implementing to ban unpaid trial shifts as part of this new legislation called the Working for Workers 4 Act. And it deals with the restaurant and hospitality industry. And what they're trying to do is implement changes so that if you are working on a trial shift for a restaurant or in the hospitality sector, you should be paid for all those hours as opposed to unpaid trial shifts. So that's one change that we're expecting in the law. And also, similarly, in this hospitality restaurant industry, there are situations, unfortunately, of dine and dash or gas and dash where people will eat or fill up and then they leave, they don't pay. And so you as an employee should not have to suffer the consequences of that. And that is something that Ontario is planning to implement as well as part of the law. So we have more questions. Let's deal with those in the time that we have remaining. So we have a question from Nick on YouTube. After complaining about another employee without any proof, the employee is now being targeted by the manager indirectly, like micromanaging the employee who complained, etc. Okay, so how to best deal with this? So this is a good example, pretty common, where you could be in a situation where you can claim constructive dismissal. So if you complain about an employee and then you are suffering what's called a reprisal as a result, so you're being targeted or retaliated against for making that complaint, then that is something that you can absolutely challenge. You can treat that as a termination of your employment and seek your full severance pay. It is a complicated situation to deal with. You want to ensure in these situations that you have everything that's possible to have in writing. So if you're like you say, Nick, if you're being micromanaged, or the person who's complained is being micromanaged by the manager, and that comes in writing in some form. Perhaps the manager is sending emails about extra work you have to do, or paying extra close attention to your work, or something like that. Something that you can prove in writing. Very important that you keep all of those records, because if you are going to challenge it and say that you've been constructively dismissed, then you want to have evidence. And having these emails or correspondence or letters, whatever it might be, in writing will be very helpful. It's more difficult in a situation where everything happened orally. Everything was just over the phone or in person. In those cases, it's a bit more difficult to prove that you've been micromanaged or harassed or something like that. So important to the extent that it's possible to get all of this stuff in writing. Okay, let's move on. We have a question from JT on YouTube. What can you do if your employer's verbal offer and the employment contract are entirely different hours, rate of pay, etc.? Good question. So, first of all, obviously, whatever is being discussed verbally should be consistent with the written employment agreement. Sometimes what happens is you have some verbal discussions with an employer before being hired, and then you sign a written employment agreement, and that written employment agreement is different. There's different terms that are there in terms of your hours or pay or something like that. It could work the other way around. It could be that you start a new job, you sign, as is the normal thing to do, in many cases, an employment agreement, a written employment agreement. That employment agreement will talk about your pay, it will talk about your hours, etc. And then maybe 6 months later, your employer says, well, you know what, we're changing these hours, we're changing your rate of pay. Well, in a situation like that, those new terms are your new employment terms, right? So if just because your employment agreement might say you make $20 an hour, for example, if 6 months later you're now beginning to earn $22 an hour, well, $22 an hour is your new rate of pay, even if it didn't come in writing, even if you didn't sign a new agreement or any documentation wasn't provided to you indicating your new terms, then it doesn't matter. It's still your new rate of pay. And usually you can prove these things with a pay stub or pay statement of some sort. So very important to note that. And we do see that all the time, where you might sign an initial employment agreement with a company, but then over time, you could be there for 30 years and things have changed, and you may not be signing new agreements every time there's a change. In many cases, employees do not. They might earn more money. They could be promoted into a different position. Many things could happen over the course of your employment, including the terms of your employment changing significantly. And that doesn't form part of the employment agreement, the written employment agreement. So want to note also, we are, as I said, we're always doing these live sessions. So we're back again tomorrow at 10:30 a.m. Pacific time with my colleague Dan, and he will pick up where I left off and answer all of the questions you might have live. So please tune in, and I wish everyone a happy holiday season, and I will be with you very again soon. Take care.